me. I'm happy to introduce our presenter today, Betsy Dulin. She's a professional engineer and an attorney, currently a government attorney in the Richmond area down at Fort Lee, and teaches graduate courses as an adjunct professor at Virginia Tech's Department of Civil and Environmental Engineering. Very delighted to have Betsy to talk with us today. And I just want to say before Betsy starts, I'm going to post in the chat, I'm going to post my email address. So anybody who needs a PDH cert, be sure to email me and let me know. So with that, thanks everyone for attending, and it's all yours, Betsy.
Okay, thank you very much. I'm just going to share my screen so we can get started. All right. Let's see. Okay, can everyone see that? Everyone's
yes.
Okay,
Yeah.
can you hear me? Okay.
Yes.
Summer is going to be monitoring the chat today, so don't think I'm ignoring you. I'm just going to soldier on, and she has promised to break in if someone has a question. I'm not thrown off by questions. I appreciate your working with me on the hard stop. A little more information on me. I am not really allowed to advertise this when we're advertising programs for groups, but I am an attorney with one of the agencies, one of the civilian agencies in the Department of Defense, where I advise on contracts, construction, IT contracts, those sorts of things, and lots of other contracts, and handle litigation associated with those. And over the years of my career, both with that and when I was in the private sector, which I was until 2 years ago, a lot of ethical issues came up with that. And I noticed that there was this real interplay between what we call ethical issues, and we'll drill down on what that means in a moment, versus the legal issues and liability that everyone's rightfully worried about. So there's my disclaimer. Don't have to worry about that. Just saying I'm not giving legal advice. We're just talking, educating, and learning today. All right, what are the major areas of innovation? That's the topic of our presentation today, specifically in the realm of innovation, something new, something innovative. It might be inventive. It might just be an inventive way to use something, or an innovative way to use something. How does that relate to ethics, and how does that interplay with some legal liability and those sorts of things? So first, I want you to think about for a minute all the things you do that might fall into that category. I've listed some things here. I've noticed that engineers, civil engineers in particular, and I'm not picking on you because I'm a civil engineer, but civil engineers in particular often will say, well, I don't do anything innovative, or, that's not me. I'm not out there inventing products or, wiring things or working with designing a new computer chip. But innovation falls into a lot of different categories. And I think all engineers deal with innovation almost on a daily basis, whether they know it or not. So think about that a bit as we're working through some of the issues today. And as I said, it's true, engineers sometimes invent things, but much more often are the frontline users of new technologies. Or even using a technology in a new way. Maybe it's a technology that's been around for a while, but you're using it in a completely different way. I wish I had a nickel for every time an engineer or one of my clients said to me, or I'm sitting at a conference and I hear an engineer say, this is the first time ever that we've ever used this particular type of material this way, or used this process. It's not new, but it's new in the context of the way it's been used. So that counts. That counts as innovation. And then I will say this too, especially for civil engineers and construction engineers and those that manage things that are going to be built. Writing specifications is a place that engineers and other designers really get involved in innovation, because many times those specifications are based on new and innovative things. Sometimes the specifications call out brand names or proprietary names of something that is new. So these are all the ways that engineers can get involved in innovation. And as I said, don't don't discount yourself when it comes to thinking about all the ways that you might deal with innovation in your professional life. All right, what are these issues we're talking about? They're kind of three categories. Some we'll spend time on today and some we will not. There are the so-called ethical issues. And I'm going to talk a bit about a word that you hear a lot now. This is kind of a, I guess you could say it's trendy, a trendy word in the world of professional ethics. It's responsible innovation. And then, of course, if you're a registered professional, there are actual rules of professional conduct that are requirements. They aren't pie in the sky things. They're requirements. And we as registered professionals must comply with them or face some sort of punishment for that. We'll talk about that. Then there are these legal issues that I've mentioned that, that definitely sometimes are caught up in the ethical issues and vice versa. Negligence, I'm mainly negligence and professional negligence, which is malpractice. Sometimes fraud, though. Sometimes products liability and contractual liabilities. And then one of the things we're not going to talk about today, but I will caution all of you, if you work in anything that is even moderately innovative or where you're doing something new that's outside the norm, is insurance coverage. Because insurance companies are, you know, obviously they're looking out for their own interests, so the policies are limited in certain situations. I'm sure you all know that if you've ever had to sign off on those policies. So I would just advise, if you're doing something new and innovative or think you might be, it never hurts to contact your insurance company and make sure you have the appropriate kinds of riders to your policy. All right, when I say engineering ethics, what do I mean? And I think a point of confusion is lecturers, thought leaders. So I talk about that, but it kind of means all these things. First of all, it means, I think the way it's used just in general use is what are these rules and ideals for human behavior? That's ethics in general. What is it that we should be doing? What's that little voice that sits there on our shoulder saying, you should do this, you shouldn't do that? And those are, in a way, social. They come from, we acquire those in all kinds of different ways, right? So that's general ethical behavior or ethics. And again, individual experience and background and context usually matters a lot in how individuals apply and perceive those rules. That's why ethics can be a gray area, and sometimes engineers and other technical professionals struggle with that. Then there's business ethics. We hear that all the time. If you watch the news, you see all sorts of issues that come up with accounting firms, with corporations and things like that. And there are kind of general codes of business ethics. Sometimes they've been embedded in laws. Usually that doesn't happen until there's some big disaster associated with that. But in corporations, if you all work for corporations, usually the corporation will have some sort of code of ethics. That's business ethics. Those who study business talk about business ethics a lot. So that interplays with this too, as we'll see. Same thing with the government, any kind of organization you're in. There's some, my organization, my agency has an ethical code of conduct. So there's always something like that. And then finally, and importantly for registered professionals, there are these rules of professional responsibility and conduct. They go by different names in different states, but they're there. And they originate from laws, from the licensing laws, and then usually the board or the agency writes regulations that have within them these rules of professional conduct. Those are legally binding. They aren't things that we just like to think about and talk about and what should we do and what could we do, but they are actually legally binding regulations. And then, and it's probably confusing the way I organize this bullet, there are codes of conduct out there. If you're a member of ASCE or SAME or these different professional groups, they'll have their own codes of conduct or canons of conduct, they're sometimes called. Those aren't legally binding. Now, if you violate them, there's probably some sort of price to be paid with the organization, but they're not laws, so to speak. So let's get into that a little more. But before we get into that, I just want to kind of raise us up a little bit into a more philosophical plane. I don't always do that when I give these types of presentations to engineers, but I think it pays to be able to, if you're an engineering professional, be able to think about and talk about these issues in a manner that others that you're working with might use. And as I said, this term responsible innovation is something you hear a lot these days. As technology advances and moves forward, many, many things are possible. And with that, and the medical profession has been grappling with this for years, is although we can do it, should we do it? That's what responsible innovation is about. And if we're going to do it, how do we do it? How do we design whatever it is in a way that's responsible to all sorts of stakeholders, the particular client or customer, the general public, society at large? That's responsible innovation, and looking at the risk and benefits, because with every new technology, there are always risk and benefits. Almost in everything we do, there's a risk and benefit. And what is that risk and benefit to all these different groups? And I'm going to, these last two bullets are things you hear a lot in other contexts of discussions about ethics, business ethics groups, philosophical groups that think about and dwell on ethics. And one is the trolley problem, and the other is the problem of many hands. And again, I only am sort of veering off course for these just so you can put it in the back of your mind and be thinking about it as we talk about some of the other things involved in our presentation today. It's interesting, you know, philosophically, and apologies to those of you who are philosophers or amateur philosophers. You know, in philosophy, the problem is the point. You know, the discussion generated by whatever the problem is, the thought process, all these things, and for engineers and others that are tasked with doing a job and getting things done for a client, it's not so much that, it's okay, how do we solve the problem, right? Some of these things are, you know, as I said, gray areas. So just keep that in mind. The trolley problem goes something like this. A train is coming down the tracks. You control the switching mechanism. This is you. Train is coming down the tracks. It's headed towards 5 people tied up on track 1. But there's only 1 person tied up on track 2. What's the ethical decision there? Is there any difference at all? Is it a distinction without a difference from an ethical perspective? That's the problem. And I can assure you, those that study these sorts of things, that discuss them, can generate hundreds of pages of writing and hours of discussion about it. And you'll see how this ties into engineering here in a second. A second version of the problem is, okay, is flipping the switch more acceptable in this scenario? And in this scenario, you still have the switch, train is still coming with a choice of which direction to go. But there's sort of this is supposed to be a bad guy for some reason in the problem. Not my artwork, but anyway, someone that is disreputable. What if that person could be thrown in front of the train and stop it and save all 6 of these people? Would that be the most ethical thing to do in this scenario? And now you're all thinking, well, come on, this is ridiculous. This doesn't apply to engineering at all. However, it does. What about autonomous vehicles and smart roads that you or someone like you is helping design? Or decisions have to be made. If there's going to be artificial intelligence that makes decisions, you have to specify how to make that decision. So in a situation where there are people in the crosswalk, whether they should or should be in the crosswalk doesn't matter, right? They're in the crosswalk, cars heading towards them, but missing the people in the crosswalk will cause this head-on collision with this other car waiting to enter the roadway. What's the ethical decision there? So that's how engineers face that decision. Another famous example of that, and I sometimes use it, I won't go into it here, is the Ford Pinto decision and discussion. If any of you are, I reveal my age when I bring that up, but for those of you of a certain age, you'll remember what happened with the Ford Pinto and the design flaw and decisions that were made about that car. And it has generated a lot of discussion. Was that an ethical decision? All right, the problem of many hands, and I think this is especially relevant to engineering. I see it in my workplace. I've seen it in every workplace I've ever been. I don't want to point the finger at one workplace because this just happens, especially if people are busy, they're multitasking, there's a lot going on, there's pressure, there are deadlines, and that is, what if a lot of different hands touched, whatever vehicle or mechanism this is, and made decisions along the way? Individuals made maybe different ethical decisions along the way. What is the responsibility of the engineer who is maybe sitting in the middle of the process, on the back end of the process, the front end, to become aware of all these different working parts before making decisions? What is that responsibility? And I think we all maybe have our own definition of that, and hopefully we'll be a little more clear after we get through the rest of the presentation today. All right, I'm going to bring us back down to ground level here, and we're going to talk about these rules of professional conduct and responsibility that are legally binding. Many of you know NCEES is the organization. They're down in Clemson, and they're the ones that write the FE and PE exams. That's how most of you know them. You might have your you might have your work record with them. But what the other thing they do is they write model laws and model rules, which are not enforceable rules and laws. There are lots of groups that write model laws and rules, and then it's up to state legislatures to adopt the model rules and laws or not, or maybe adopt part of them or edit them. So we have these different states, some of which have just wholesale adopted the NCEES model rules, and some that haven't, some that have sort of adopted them, but have their own flavor and their own parts and things like that, and some that haven't. Occasionally NCEES will propose a rule. Actually, I only know that this happened once in my career lifetime, and no one adopts it. And that was when NCEES proposed the bachelor's degree plus 30 hours rule several years ago. And not a single state was willing to sign up for that due to a very strong lobby from some of the consulting engineering groups and others. So sometimes no one adopts the rules, but in the case of codes of conduct, all the states have done that. By the way, in Virginia, I was very impressed when we moved here, and I applied to have comedy admission as an engineer here, and I was required to take a course/test on Virginia's law and rules. It's easy, it's not closed book or anything, but it forces you to read them. I think that's a very good thing. So Virginia is a state that does that. Professional societies, as I mentioned, have their own kind of codes of conduct required as a condition for membership, not legally enforceable. And then government contracts often incorporate by reference state and federal statutes and other things related to ethics. So that's always something that's worth checking. These are just, this is the part of the Code of Virginia, which is the law that the General Assembly writes, charging the board, which in Virginia has a very long name. It's one of the oddest acronyms I've ever seen, to write rules of professional conduct relating to these areas, right? I won't read these to you, but clearly, as you'll see as we go through this, some of the kind of big ticket items, big ticket areas regarding professional conduct and engineers. So the board is authorized by the General Assembly in Virginia, and this is true in other states too. I'm using Virginia as the example. Virginia also, as part of that law, has a practice of engineering statute. And it's important to remember this is also part of engineering ethics, and there are cases about this. This is a place that engineers and their companies can get into real legal trouble. And not just with the board, not just with some kind of admonishment by the board, but actual legal trouble in a civil litigation sense. And it defines what is the practice of engineering. And almost none of us ever look at this on a regular basis, but it's worth doing. This is something that is different from state to state and has been enforced differently by different boards and courts. Usually in Virginia, this is true, as in other states, certain types of engineers are exempted. And there's a big debate going on about that right now in NSPE. NSPE, I have been heavily involved with VSPE and NSPE, and the position of that group is definitely everyone should be registered, period. But for now, government employees, corporate or in-house engineers who are, as the statutes say, practicing engineering on their employer's property. And you know, that's kind of an old concept if you think about it. How many of you, even if you work for a corporation, just practice engineering on your employer's property? Not many. So they're a little bit, that's kind of outdated, but those exemptions are still there. These are the key rules, and I'm not going through, you can look these up. If you go to your state board's website, there will be a link and you can look the rules up yourself. These are the areas that are covered by all rules of professional conduct in all the states that I'm aware of. Number one, protection of the public. This is something that absolutely sets engineers apart from usually all the other professionals and players that are working on a project with the engineer. We'll talk about that. Practicing, making sure you're competent in what you're doing, being objective and truthful, avoiding conflicts of interest, using your seal appropriately, you know, not just using it as a rubber stamp on someone else's work or something like that. Unfairly competing with your peers. That's usually covered in the rules of professional conduct, loosely enforced by most states, but it's there. And then also a rule of confidentiality, not as strong as the law as the lawyer's responsibility of confidentiality, I might add, but still there. Okay, what are the common areas of tension? The big one is this duty to protect the public welfare versus all the other responsibilities to everyone else, your peers, your clients, everyone, the world, okay? Because engineers, there's in every code of conduct, whether it's state rules or professional groups, model rules, always says right at the beginning, protection of the public welfare and safety is paramount, is first and foremost. Words like that are used, okay? And that trumps everything for engineers. That's not true for other professionals. It is not true for other organizations that might be working on a project, like contractors, whatever. True for engineers. And it puts engineers in tough positions sometimes, I will say that, legally. Then there's, you know, sometimes what's the responsibility of the client versus the employer. Again, pressures within a project in the context of the fact that in of a world where engineers have this higher duty to the public welfare. And in the background of all of that are contractual obligations. Someone always asks, well, what about all these contracts I signed where I agreed to this and I agreed not to tell that, and I've got this confidentiality agreement in the contract, but I've got to go protect the public by revealing a confidence. What about that? That happens. And, you know, there are situations where engineers had, you know, did the right thing under the rules. There's a very famous situation involving a structural engineer in New York City and a high rise. You can Google that, where the engineer stepped forward and said, you know what, there's a flaw here. I know the building's halfway completed, but we have to start over. and he got sued. He is held up as an icon of ethics, but he did have contractual obligations, obviously, to his client, and which they are, have the right to do, were able to recover the money. I think he probably lost his insurance. I think he might have lost his business. I can't remember all of the story, but that's where the tension is. The easy ethical issues and contract issues no one cares about because we just go about and take care of them every day. But these are the kind of the tough areas. Virginia also has in its rules, which I think is interesting. All states have this too, but Virginia's are worded a little bit differently. What about others that are violating the law or rules related to professional engineers? For instance, you're working with a vendor or subcontractor, and someone is blatantly, obviously to you, practicing engineering without a license. What are your duties there? And Virginia has, this shall not knowingly associate, and if an engineer has direct knowledge of that or a reason to believe, which is different than direct knowledge, then that person shall immediately inform the board in writing. There's also a provision in Virginia, which I didn't cite here, that says if your judgment is overruled as an engineer, and a great example of that is the Challenger ethical decision, where there was an engineer the night before and the day before losing his mind almost because he was trying to get the word out and get everyone to listen to him. But there, in Virginia at least, there is a provision that said if your judgment is overruled, you're required to keep going up the chain and even outside your organization until the word gets out. And I know board members here, and they'll say, well, I'm not sure we've ever enforced that. And that may be true. However, we'll see in a second how that it applies to some legal obligations as well. As I said, with these rules that are embedded, that in regulations that an agency like the board in Virginia passes, there are some statutory penalties for violating the rules of professional responsibility, and that happens. Engineers sometimes get it. It's rare that engineers lose their license. It's more common. There are penalties. There are many penalties. Sometimes there's publication. Sometimes there is temporary suspension, but it's there. And with even criminal penalties, if there's repeated offense, someone who is a perpetual offender when it comes to a particular rule. And then there's professional malpractice, which we often forget about. If you're sued for negligence or malpractice, in the case of a profession, the standard you're held about is, okay, what would a reasonable professional have done in the same or similar position? And so the court is going to have to, the person suing you is going to have to show that you didn't follow that path that a reasonable professional would have in that situation. You're going to be arguing that you did. The decision maker is going to have to decide that. What did they look at? Industry practices, codes and criteria. That's why we look to and follow codes in engineering. The steel code isn't a law, but you know what? It's a code. It's a standard. It's a professional practice. Metcalf and Eddy, if you're in wastewater, it's certainly not a law or regulation, but there are some things in there that maybe all wastewater engineers in the industry adhere to, on and on like that. There are many more, obviously. The scholarly literature, what's the best practice? And in the age of the internet, it is just presumed that all of this is available to you all the time. You should have known, right? Did you know, or should you have known about these things? And then here's the other category that's important for our rules of professional conduct. Regulations that are actually rules actually can also be used as standards of conduct, not just for engineers, but for everyone. And in fact, different states use them, different state courts view them in different ways. A minority of states say breaking a rule or violating a rule or the law is conclusive proof of negligence. If the plaintiff can prove that you violated a rule or a law, they're done. They don't have to go back and talk about what are the industry practices, what's in the literature, what you should have done. It's just done. QED, you were negligent. That's a minority of states. Another minority of states call it a rebuttable presumption of negligence. So the defendant can come in and try to rebut that presumption of being negligent if the defendant violated a rule or a law. Most states say that these rules of professional conduct or any regulation is evidence of a standard of care. And if you're in the group of people subject to that regulation, such as engineers are with codes of professional conduct, then if you violate one of those rules, it's evidence that you did not meet the standard of care. You did not behave as a reasonably prudent engineer in same or similar circumstances, because that's the standard you're being held to with negligence or malpractice, this elevated standard of care that someone with your education, your experience, your skill set, access to things that you have access to, what would that person have done? That's the standard you're held to. And the fact finder or decision maker will decide that. So some state, an extreme minority say, no, it's not applicable at all. But, I probably should have left this one off because that's an extreme minority of states that come out with that. And importantly for us in Virginia, the Virginia Supreme Court has weighed in on all of this in 2016 in a case that got national attention from all the consulting, ACEC, NSPE, corporations, insurance companies, and found in a case violation and explicitly said violating the rules of professional conduct, even if there's not a formal finding by the board. So you don't need to go to the board, get a formal finding that, the engineer violated our rule. But even without that, if the plaintiff can show that the engineer arguably violated that rule in a fact-based way, then what the Supreme Court has said is that can be used as a primary means of defining a standard of care for professional engineers, whatever that professional rule may be. I'll mention a few things related to that here in a minute. Now, what's an example of all this? A great example of how all this comes together is a typical design build project. And this isn't a design build seminar, so I apologize to those of you who aren't in the business of this or aren't familiar with it. But typically, in kind of the old days and traditionally, owners went out and contracted with an engineer to design something, and then the owner separately contracted with a contractor to build it according to these specifications that the design engineer had drafted for the owner. There was no contractual relationship at all between the engineer and the contractor. Sometimes it can feel like it if the owner also contracted with the engineer to be inspect part of the construction or all of it. Sometimes it felt like there was a relationship there, but there's really not a contractual relationship. With the design build project, and this applies to design build, P3 projects, all these things that we hear about and watch. The owner has a contractual relationship with some entity that is a design builder, right? But doesn't have separate contracts with the architect engineering firm or the designer. The architect engineer or designer is embedded into this design build entity, okay? The owner might also have a contract kind of out to the side with the quality assurance manager that's usually another engineering firm. But as far as just getting the project designed and built, there is this entity, and that's either a joint venture of a lot of different firms, usually a big contractor that's a specialty contractor, one or more design engineer for, just kind of general design engineer firms, all sorts of specialty design firms, consultants, that sort of thing. And that might be a joint venture, which is kind of like a partnership legally, except it's companies in the partnership and not individuals. Sometimes the contractor is the entity and will just subcontract to the engineer, to the designers, and everyone, actually, just like they would do with any other subcontractor on a project. That puts an engineer in an especially tricky position with respect to rules of professional conduct. But importantly, and I mentioned this before, this is a situation that illustrates something where only the registered professionals, the architects and engineers, they are the only entities on that team usually with special responsibilities under the rules of professional conduct. And here I'm talking about the first and foremost rule that engineers, architects have this rule too, will protect the public welfare and safety. Usually the only people in that team that have that in the code of professional conduct that is legally binding, and that can also be used as a basis for malpractice, as we've just talked about. So big difference, right? And of course, all members of the team could be liable for negligence. They'll be held to the negligence standard in their own field. Again, if it's a contractor, it's what would a reasonably prudent contractor under same or similar circumstances do here. So that's different, because the contract, that entity may not, is probably not going to be, they're not doing design work, they're not being held to that standard. So, and this is how cases go. I mean, that's what your lawyers do for you when they represent you in a malpractice action. They're out there looking, they're using these standards, and then they're looking at case law, maybe trying to find cases similar to what's going on in your situation, where the outcome, where it's analyzed a certain way. These things are all very fact specific, as you might imagine. If you've got a situation where every time the fact finder has to decide, okay, in this particular situation, with the defendant with this particular skill set, background, designation, professional registration, what would that defendant have done? What should have been done or not done? That's very fact specific. So it's important, obviously, that your attorneys get down and really get into the details with you about that, which I know is uncomfortable. To highlight the fact that the engineering members of the team kind of have this special obligation professionally, and which again matters legally, because if you don't meet your professional obligation, arguably haven't met the standard of reasonably prudent engineering. And most standard forms of agreement between design builder, DBIA, or any of the other AIA agreements, any of those standard form agreements, lots of government agreements that deal with design build, there's usually something like this in there, which says the design consultant part of the team shall use care and skill ordinarily used by members of the profession practicing under similar conditions, following those same kinds of performance standards and all the things you would expect of this reasonably prudent engineer. So the agreement states this, but it's really nothing that wasn't already out there in tort law or negligence law, right? This is the standard that you're held to when it comes to malpractice. It also happens to be the standard that you're held to if you enter into a design build agreement with an owner and you're the design and you're part of the design piece of that team. What is the contractor standard of care in a design build? Obviously, the contractor's warrant to the owner that all work's of good quality, it's free from defects, it's in conformance with the contract documents. Contractors, sometimes that is called the contractor's warranty or something like that. It has different names in different states and depends on what type of law we're talking about. And they warrant that whether it's in the contract or not. That's an implied warranty. The contractor also, though, under decades of case law, construction case law, is privileged under the Spearman Doctrine to follow designs and plans that the engineer, and this is a traditional project, right, where the contractor is presented a set of plans and specs that an engineer has put together. If the contractor follows those, then the contractor can't later be held liable to the owner if something is defective or goes wrong. That's called the Spearman Doctrine. That's become murkier in the age of design build. The courts are still trying to figure that out, and court system is usually 10 to 15 years behind. So, but it still underlies some of the relationships. I'll leave it at that. It's a whole other hour-long seminar to talk about that, or you can take one of my classes at Virginia Tech, and we talk about that quite a lot. Anyway, that's something to be concerned about. Well, what do you do if you're that engineer? Yeah, you're in a tough spot. How do you protect yourself? Obviously, the engineer has to stand up for itself and manage its communications, the owner. And try not to agree to a situation where you're never going to be the one communicating with the owner, but must always do it through one of the other parties. That almost inevitably leads to problems for engineers. And I know engineers agree to contracts like that all the time, but it's problematic. I'll just leave it at that. What about innovative products and technologies, right? True cutting edge stuff, right? Again, there is this protect the public welfare part of the rules of professional conduct, and those still matter, even if it's an exciting new innovative product. In the Supreme Court of Virginia, I've already referenced this in a case, which if any of you want the name of it and all that, or want to talk about it more, feel free to email me, or you can probably just look it up, because it was a pretty famous, was in 2006. Showed this judicial willingness to use rules of professional products, rules of professional responsibility in situations where there's a new product on the market, a new proprietary product that the engineer spec'd. And again, we'll circle back to that, but it's a little, I have to do a little side seminar here on this slide on products liability. And products liability claims are different than negligence. And one way that they're different is manufacturers of products can be what's called strictly liable, or liable without fault. So what we just said about negligence for design professionals is if the fault matters, and the fault is, did the engineer behave as or act as a reasonably prudent engineer under same or similar circumstances? That's fault. In products liability, their manufacturers can be liable strictly. In other words, someone is hurt using the product, manufacturer's liable. That's strict liability. Most states have some form of it. Some have very draconian cases about holding manufacturers strictly liable if someone is hurt or damaged, or there's some damage from use of their product. But that's called liability without fault. And it's, in some ways the product's defective, it's not fit for intended purposes, or even it's reasonably foreseeable uses. If someone might be misusing the product, that still can result in liability for the manufacturer. That's why you see warnings all over products. Do not do this with the product. Do not do that with the product. That's why those are on there, is to try to minimize some of that liability. But engineers have mostly escaped from that, and other professionals, because we're judged by this negligence standard. But engineers do write product specifications. And so in this, I did provide the citation to the case here. I'd forgotten that I did that. In this William H. Gordon case, the Supreme Court said, when it comes to a new product and the engineer is specifying it, and some other party has just invented this product, and in this case, it was not a very flashy or exciting project. It was a drainage system. It was something called the rain tank that was underground, a tank underground and it involved stormwater drainage, things like that. that ruptured. And it wasn't a big, no one was injured. There was property damage. So it wasn't something like that. It was kind of a run of the mill, if you will, civil engineering situation, but it was a new product. It had just been patented. And the contractor came out totally clean because it was traditional design bid build, and the contractor did what the contractor was supposed to do in that situation and went to the engineer and said, wait a minute, I don't think this is right. I don't think this is going to work here. I don't really understand these manufacturer specs. And the engineer did not help the contractor with that very much. And so the engineer ended up losing at the trial court level and Supreme Court level in a way that created a concern in the professional community that this liability is creeping closer and closer to strict liability. And we don't know yet because this is pretty new. No other case, it hasn't really been cited by other courts in other situations. But at the very least, the Virginia Supreme Court case told us that engineers have some duty to investigate products in the site and may have additional due diligence if they're specifying the product in some way that is not exactly like the manufacturer specifications have recommended, or it's some new way. And the engineer is not entitled to just blindly adopt plans and specifications prepared by manufacturer, especially if if a registered engineer, and this is where the rules came in, a registered engineer did not oversee that design for the manufacturer. And then the special concern with respect to innovation, and in fact, NSPE and ACEC, their amicus brief, talked about this quite extensively. This is going to deter innovation. So that, because the Supreme Court came out and said, the trial court definitely came out and said it, Supreme Court tiptoed all around it, but there's some sort of enhanced diligence. We don't know what that is. The court hasn't told us yet if it's a new product. Okay, let's look at a couple quick examples, and I'm not going to, if we were in a different setting, we'd have a big group discussion about this, but it's not that setting. And I just want to run these examples by you to sort of bring some of this to a real concrete level, and it's something for you to mull over while you're at your golf outing. How about that? All right, example number one, and these are all true events and things that really happened. Some of them are real obvious, will be obvious to you, and some won't. Some of them might even have photos. In this one, it's a situation where an engineer works for a firm that designed fast track project, this pedestrian bridge over a busy multi-lane highway over a university campus in a fairly busy city and state, and the bridge collapsed at a traffic light. And those sitting under the bridge, so were injured, they were killed, there were people killed. There was a investigation. There have been several years of lawsuits with lots of different defendants, but the engineer and the design engineer and colleagues told the NTSB investigators that the scope of the project, combined with the enhanced schedule and the limited budget, did not provide for the type of design that would have caught what turned out to be design errors. So think about how that fits into those rules of professional responsibility. Engineers under real pressure, as you know, this happens. We all know it happens. It's very common. But what was the engineer's broader obligation there? And the engineers, as I said, admittedly in the report said that we would have caught those if we would have had more time and a bigger budget. Here's some photos of the collapse. It's in Florida. Some of you might have, the engineering community, there was a lot of buzz about this at the time that it happened several years ago. So you've probably read about it in some of your engineering publications. I think all of the defendants ultimately settled. So you won't see any court cases about it. All right. Example number two. Engineer specifies a certain brand of guardrail using new and proprietary technology to absorb the shock. It's a guardrail pad at the end to absorb shock in collisions and theoretically minimize vehicular damage and personal injury. However, it turns out after multiple accidents that the way the guardrail behaves in crashes is part of it rolls back, and there are videos of this online if you're interested in this topic. It rolls back, and it effectively, the guardrail becomes a spear. It pierces the passenger compartment of vehicles, and people are killed and very badly injured. Here's some photos of some of the testing, and here was the previous design, and then this design. If you're in Virginia, Virginia DOT actually did its own product investigation of this and ended up banning the new design a couple years ago. But what if you're an engineer and and you specified that guardrail, and you started seeing on television, because it was on some of these shows where they tell us these things have happened and interviewed people that are injured, and you start seeing these things come through. What are your obligations? What were your obligations on the front end of the new product? All right. What about autonomous vehicles and the fact that there was just one the other day. It looks terrible. Everything burned up. But nevertheless, the CEO of the engineer's company, and this is true, remains aggressive and has said repeatedly in public he believes it would be negligent not to do it. So remember, if we can do it, should we do it? And the owner of this technology, or one of them, has said a lot. We have to do it. Not to do it is not to use it is negligent. So that's an ethical issue for engineers. Here's some of the crash scenes. All right. What if you're an engineer and you're going to use this particular type of trenching technology to build a huge tunnel under the ocean from a platform in the ocean for a longer tunnel span that's been attempted in any previous project? So this is the classic. These are all things that existed before. But what are some of your considerations on the front end regarding your ethical issues? How are you going to try to protect yourself in your contractual and business relationships? All right, did I get them all? Yes, I did. Here's the last example. What about alternative technical concepts? This is a very big thing in highway projects now, where engineers and contractors work way on the front end of projects to help the owner explore different ways to design the project, and even go beyond the design elements and the geometrics of the roadway, but look at things like operational limits and things like that. Is that okay? Yes, of course it's okay. It's good for all of us, I think, if engineers are involved earlier and thought is put into these things. But how do you, again, if you're the engineer and you're the one with these professional obligations that others on the team may not have, how do you approach this? What recommendations you made? And, I saw an engineer in a situation like this. That was one of my clients that was being confronted by the owner and the contracting partner in a design build involving, speed limits and decisions like that had been made. And the owner and the contractor both raised the issue that, hey, you as the engineer had this overarching obligation to protect the public welfare. You're more liable than we are, said the contractor, right? That's on you. That wasn't on us. So these are tough, again, very tough positions for engineers sometimes. So just think about that. I threw this slide in. I'm not going to get into this today because this is definitely some high level stuff, and I can hear your eyes rolling already. But there are thought leaders in engineering ethics. There's a lot of writing about it. Conferences, that sort of thing. And there's a new discussion, given all the new technology, there's a lot of discussion out there about, hey, maybe we're in an era of the so-called third generation of ethics, which is less situational. First generation, we focused on the legal compliance. Second generation, we started to look more at these so-called secondary stakeholders, the larger community. thinking even more about the public welfare, if you will. But this third generation, the writers argue, should focus on, and I won't quote it to you because I'm not exactly sure what it means, but what I think it means is the broader global community. It sort of goes back, yes, there's some issues here, there's some dangers here, but it's good for the community, it's good for the country, it's good for the whole world if we go ahead and design this. And engineers shouldn't be on the hook for doing that. Engineers should be praised for doing that. Engineers shouldn't be punished for helping that along. That's the discussion. So at the very least, you can throw that out at a dinner or cocktail party, and looks like you think about these issues all the time. Make sure you mention responsible innovation while you're at it. All right, to end up here, I just wanted to throw out some kind of risk management guidance. How do you balance all that if you're in this business? And again, it's very tough. And in situations where, especially involving litigation, usually the design professional is the person in the room that I have the most empathy for and sympathy for. And I don't think that's just because I am an engineer. I've had law partners that aren't engineers that felt the same, because there are these competing obligations and tensions. So first of all, don't assume everyone knows what you know and are totally familiar with ethical obligations. Even someone that went to college and was educated as an engineer and even had an engineering ethics class, don't trust that. Make sure that you have your own education system in place, that you've created protocols, that you have a system that's open and a culture of honesty and open communications. Ideally with a point person or lead person. Law firms always have that. There's some point person that is the ethics officer of the firm, and that's the person that everyone can go to in confidence and say, wait a minute, I think there's something wrong here. I feel funny about this. I want to know exactly what my professional obligations are. That's definitely worth doing. Government agencies have that person. So that's important. Again, continuing ed is big. And then what about, because the hard areas are these gray areas, what's the system of reporting and reviewing them? Does your firm have, or your company have, a way where that can be done in the right type of atmosphere? Because again, this is dynamic, it's changing, technology's changing, and we have to be light on our feet and have something set up that's flexible and dynamic enough to keep up with changes and to keep up with employees whose educations are changing in different ways. Engineering education has not been static over the last 20 or 30 years. It changes. The criteria that ABIT writes have changed a lot since I was in engineering school. They're, virtually unrecognizable now from that model. And so it's important to keep up, and ethics are always a part of that. All right, that's all I've got for you today. I don't think anyone had any questions as we went along that I missed, but if so, I'm out there. You can look me up. I might see you at an SAME meeting, and I think your group leaders have the information and material.
Yep, thank you, Betsy. We will be putting this recording on our website, so everyone will have access to it after this program ends. Again, thank you, Betsy, for your time. And if anyone has a quick question, there was nothing that I saw pop up in the Q&A.
All right. Well, thanks for inviting me, and hope to see you again soon in person.
Thanks, Betsy.
Yeah.
Oh, it looks like, yep, just a thank you. So we'll go ahead and let you get going to your next meeting. And just as a reminder, we've got some upcoming events. We have the golf tournament on May 27th. We have a joint post event pre-Jesse, why you need a personal brand and how to develop it. Victoria Meckley from RSNH will be presenting that. And registration is open for the Joint Post Mid-Atlantic Small Business Conference. All of those events are on our website calendar. You can get to them by going to sme.org/centralva. And just thank you to our annual sponsors again. Everyone have a great afternoon, and we will see you at the golf tournament on May 27th.